Investigators are trying to figure out how 6-year-old Wongol Estefanos died on a ride at the Glenwood Caverns Adventure Park. It's bringing up questions on just how liable the amusement park is in the death. 9 News legal analyst Whitney Traylor joins us live to talk more about this. Good morning, Whitney.
Good morning, Corey. Good morning to all the Colorado viewers.
So is it fair to say, in light of the child dying on the ride, that someone will be held accountable, someone will be liable?
Well, you would think so, right? The fact that a small child, the investigation's ongoing, so we don't know the facts or all the facts, but what's being reported is that the small girl fell over 100 feet. And so if that happened, generally that doesn't happen without someone being negligent, right? If everything's working as it should be safe, but that's not always the case. And then the second question is, well, is there liability, and can we determine who was actually liable? Did somebody fall below their duty of conduct? And that calls in to play these waivers of liability that people are often asked to sign. And it's interesting because there's a bigger picture here, because when we're talking about legal liability, there's this notion that the companies are really pushing the cost of their negligent conduct to the consumer. And so some are questioning the fact that we can even do that in our society. We may need to rethink some of our business systems, if you will.
Yeah, so this waiver, the park has this activities waiver that requires anyone entering to the park to sign it. If this document was signed by the parent or legal guardian of this young girl, which we don't know yet, what does that mean for legal liability?
Well, that's going to be very significant. That's going to mean a lot. And in fact, their waiver of liability, the document is actually on their website. And so I was able to look at it yesterday, and it is very detailed. There were three primary aspects of it that I think are relevant. Assumption of risk, basically saying, look, if you come into the park, you know that these rides can be dangerous and that people can get hurt, and you're assuming that risk. You're saying, I'm taking on that liability. And then, of course, they have a release and waiver of liability, which says, hey, even if we as the park are found to be negligent, if we did something wrong, you're still waiving any rights you have against us. And they're saying you will indemnify us, saying basically, hey, if we have to spend anything on this, the patron will actually reimburse the park. But,
wow,
the waiver, the big picture here is, or the ultimate point is, these waivers can be enforceable. And even when the parent signs on behalf of the child, some states don't allow that, don't allow a parent to waive the liability for the child. Colorado does allow this. And this same park was sued in 2015, and a woman broke her back. And they used this waiver of liability as a defense, and the court dismissed the case.
So that was my question. Like when you go to a hockey game or when you go skiing, on the back of your lift ticket or your event ticket, it says the same thing that this waiver has. Are these really enforceable? What typically happens in these situations?
That's a great observation, and a very it's a good question. And those are called exculpatory clauses, and you see them sometimes even in the parking lot where the sign says we are not responsible for lost or stolen articles. But you're exactly right, Corey. On the back of your ski lift ticket, when you go to a baseball game, it's generally on the ticket. And basically, they're saying, hey, these are dangerous activities. You're acknowledging this by even participating, and therefore we won't be liable. And so, like, even at Elitch's has a link on their website that specifically says, hey, by purchasing a ticket, you're agreeing to hold the park harmless from any claims, including death that could have resulted from the park's own negligence.
It might be too early to tell, but what are the chances that this goes to trial? And if it does, what do you think are the likely possible outcomes?
It is early to tell. And honestly, I could see, I guess, three possible outcomes, which would be settlement, or it could go to trial, or if there was an arbitration provision, it could have went to arbitration, but there wasn't here, which is a little surprising. So honestly, if it goes to court, obviously the park is going to rely on the waiver. Now, the waiver is obviously enforceable. It worked in 2015, but the question here is, the waiver releases the park from basically acts of negligence. But when the standard goes to a standard of recklessness, when the park may have been reckless, meaning it's so outrageous, it's almost intentional. So if, let's say, the actions of the park were deemed to be reckless, then the waiver probably wouldn't matter. But that's an issue of fact. So, if the parties don't settle, it will likely go to trial, and it may get dismissed before a jury ever even sees it because of the waiver.
Ah, no matter what, no matter how you cut it, it is a terrible, terrible story, and I just feel for that family for sure. All right, Whitney, thank you so much for your perspective.
Sure. Thank you.